So we finally have some movement and a ruling from Sacramento in our challenge to the 11% excise tax set forth by Assembly Bill 28 a couple years ago. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we are finally seeing some movement in the challenge to the 11% tax on firearms and firearms parts here in the state of California. That, of course, is Poway Weapons and Gear versus the California Tax Board. This comes from Assembly Bill 28, which imposed that 11% tax just a couple of years ago. And to walk us through that today, we have brought back CRPA's president. That, of course, is Chuck Michel. Chuck, thanks for being on with us today.
It was a pleasure, guys. Thanks for having me.
Absolutely. And guys, as always, please be sure to like, share, and subscribe to these videos. I hope that we have earned these likes, shares, and subscribes. We've got a lot to look forward to with a lot of litigation moving forward. And we have the elections that we're covering all the way through to November. So we're trying to spread the word far and wide. We're trying to progress the Second Amendment movement here in the state. So if you can, help us out, like, share, and subscribe to these videos. Really helps out the channel. Let's just go ahead and jump right into this, Chuck, from the Sacramento Superior Court. We got this yesterday. It reads like this. Under the Bruen test, a court first determines whether the plain text of the Second Amendment covers the conduct at issue. Here, plaintiffs' commercial retailers who want to sell firearms without paying the AB 28 tax, whether the cost is paid for by them or passed to their customers. Defendants argue that the plaintiffs are not among the people the Second Amendment protects, and thus the analysis fails at the outset. Although the Second Amendment directly protects only an individual right to keep and bear arms for self-defense, courts have consistently allowed commercial retail sellers of firearms and ammunition to assert rights on behalf of their customers in court. For example, the Ninth Circuit observed in one case that the would-be operator of a gun store has derivative standing to assert the subsidiary right to acquire arms on behalf of his potential customers. The court construes plaintiff's complaint to allege that the law is unconstitutional on behalf of their customers and then to assert plaintiff's right to a tax refund on that basis. Plaintiffs, for their part, argue that the right to acquire and to sell firearms is within the plain text of the Second Amendment and presumptively protected. This is not correct. On its face, the Second Amendment says nothing about commerce. The right to acquire firearms and ammunition is ancillary to the core individual possessory right of the Second Amendment. There is no right to sell a firearm unconnected to the rights to keep and bear arms. The court finds that the plain text of the Second Amendment does not cover the conduct affected by the AB 28 tax. The court, therefore, does not progress to the second step of the Bruen test, historical analysis. However, because a right to purchase and sell firearms and ammunition is ancillary to the core protections of the Second Amendment, plaintiffs' claims do not immediately fail. The complaint may state a claim based on the meaningful constraint test. So right there, it kind of sounds like they're failing it on behalf of the first test of Bruen, even though there is precedent within the court that retailers do fall under that first step. Which is kind of weird, but then we can get down to the disposition where it says this. Defendant's demurrer to plaintiff's complaint is sustained in part and overruled in part. The court grants leave to amend to attempt to state a claim within the meaningful constraint framework if the plaintiff has not had an opportunity to amend the complaint in response to the demurrer. Leave to amend is liberally allowed as a matter of fairness unless the complaint shows on its face that it's incapable to amend. Leave to amend is granted as the defendant's first challenge to the complaint on which the court has ruled. Plaintiffs may file and serve an amended complaint no later than June 25th, 2026. Defendants shall respond as directed by Code of Civil Procedure, Section 471.5 and California Rules Court 3.3120J. This minute order is effective immediately. No formal order or other notice is required. So I guess, Chuck, let's first start with the verbiage here, because we don't see this a whole lot. What is a defendant's demurrer to plaintiff's complaint? In court speak, what does that mean?
Okay, so take a step back first. This is a challenge to a tax, an excise tax being levied on firearms and ammunition by the state of California. Tax litigation is a very specialized subsection of general overall civil litigation. And there are constitutional aspects to this tax challenge, but we had to pay the tax first and it's supposedly only the taxpayer or the payer who pays the tax through the dealer who's the taxpayer has standing to challenge the tax. So you have to do it. Only taxpayers have standing. And what they're arguing here is that, first of all, and this is the kind of game that the state plays. They want to wrap us around the axle with this standing issue. So they file a demurrer. It's basically you file a lawsuit and they file a demurrer. The demurrer is kind of like a motion to dismiss. It's basically saying, so what? Even if everything in your complaint was true, you don't have a viable cause of action. So we're demurring. We're basically saying, so what? You lose anyway. So that's what was heard here. It was a hearing on the state's demurrer. They demurred because they said they're not the taxpayer, and then they're trying to argue that even if the dealers and the buyers through the dealers have standing, then it's not a meaningful constraint on the right to keep their arms to pay an 11% excise tax. So the court issued a tentative ruling, and this is not unusual in state trial courts especially, but also in federal trial courts. You get a written opinion the day before the oral argument. That doesn't happen in appellate courts, just in the trial courts, because the court wants to narrow the issues that are going to be addressed at oral argument. So they issue a tentative ruling, and it's very, very rare that you can make a court change their tentative ruling or withdraw their tentative ruling and issue a different ruling. So what happened here was the court issued a tentative. They did their oral arguments. The court adopted its tentative. What the tentative says is you can have derivative standing. So state your argument that the plaintiffs in this case don't have standing to challenge the tax goes away, but you didn't allege a sufficiently meaningful constraint on the right to keep and bear arms because of the imposition of this tax. So we're going to give you an opportunity to amend your complaint, beef up your allegations about a meaningful constraint, and then we'll have another hearing on this and see if the case moves forward.
I was going to ask you about that. So you're saying that's something that we do, I guess, typically see in courts, because up until this point, I had only seen, a ruling that was actually provided before the oral arguments. That was in Richards. So this isn't necessarily a state court thing or a federal court thing. This does happen pretty often.
Well, yes, but in constitutional litigation, it's happens less often because the issues are so sort of sophisticated that the court doesn't necessarily want to narrow its ruling down before the oral argument in a trial court. But it's not unusual to get a tentative ruling from a trial court.
Well, and we read the quote here, so they did talk about the first test or the first Bruen test, but what we didn't read was them going into the meaningful constraint test. Can you give us some insight into this meaningful constraint test and how they applied it here?
It's a real problem because it's a creation of the Ninth Circuit, and they did it to us in the BNL gun shows, the Crossroads of the West gun shows case, and created basically a whole nother level of review that gives the state an out. In other words, if you're not, remember the Bruen test is it covered by the language of the Second Amendment, right to keep and bear arms, and the Bruen test says, first of all, you figure out whether it's covered by the express language of the Second Amendment. Is it an arm? Are you part of the people? Is there an infringement? And then then you look at historical, if it's covered, then it goes to the historical analysis, historical analog analysis, where you look to history and see if there was a historical law similar to this one that would justify the modern law or suggest that the founders would have tolerated the modern law in their minds when they were writing the Second Amendment. Now, there were no taxes like this for firearm purchases at the time of the passage of the 1791, when the Bill of Rights and Second Amendment was being adopted. So there should be no historical an analog. So what they try and do is the Ninth Circuit tried to do is create this other exception, the meaningful constraint requirement that says unless there's a meaningful constraint on the right, it doesn't matter. And that's complete baloney. and it's come up in several other cases. The United States Department of Justice has come down on our side on this in the Rhodey case and a couple other cases that we have on appeal in the Ninth Circuit. So we're very hopeful that the Ninth Circuit will get rid of this because it's now being adopted by the state court in this Poway uh, uh, firearms retailer challenge to the state income to the state
Yeah,
excise.
and they cited the B&L case when they were discussing this. I mean, is this meaningful constraint essentially the Bruen version of interest balancing? How
The Heller version of rejected of prior to Heller interest balancing. Yes, it's like undue burden in an abortion context, or it's complete. It is absolutely interest balancing with a mustache. It's like, is it worth? It's if it's so minimal, is it a significant enough infringement to justify it being struck down on Second Amendment unconstitutional grounds? That's not the test. It's if there's any infringement is a Second Amendment violation, and an 11% excise tax is an infringement. There's no question about whether or not it's a meaningful constraint, but we have to go through the motions now and argue that until the Ninth Circuit or the Supreme Court, and this will be something that comes up in Duncan too, or one of these other cases that gets accepted by the Supreme Court, and hopefully it's Duncan. All fingers crossed. Uh, but it's something that needs to be set straight because this meaningful constraint test is an out that the Ninth Circuit is trying to give the government so they don't have to meet their burden of proving some kind of historical analog law.
Yeah, and we talk about it a lot. This is the other side's political activism at work. I mean, you have the Bruen test that literally takes away the interest balancing, and then they just slap another name on it, which is meaningful constraint test, and start using it again. So this is kind of the part that makes it a shame that this continues need to be clarified. But here it is popping up again. I'm curious, can you go into this as well? I have a hard time understanding how you would put a retail store under the concept of an ancillary right. To me, it seems pretty straightforward. You have the Second Amendment right to purchase firearms. You can't purchase those firearms without the retailers. Can you explain this on both sides? How are they categorizing the retailers?
Gun store corporation doesn't have, it's an individual right. It's not a corporate right to keep and bear arms. So a gun store doesn't have the right to keep and bear arms. The owners of the gun store do. The customers of the gun store do. So when he's saying an ancillary right, the court was saying, the gun store itself is not a person, so it doesn't have a constitutional right, but its customers are. It's an ancillary right that then derives to derivative right that goes back. The gun store can assert it on behalf of its customers. So that was the standing issue that I think they finally got around. This case has just been dragged out for a long time because tax litigation is so procedure specific. You have to challenge it in front of the tax board first, then lose, and then go to court. So we had to refile this to go back rather than fight that, which you shouldn't have to do in a constitutional context. But rather than fight that, we went back and went through the administrative hearing process with the tax board, lost, no surprise, and then went to court. So that prerequisite was checked off so we could get to court. Then once you get to court, you still have to go through all these state procedural roadblocks that they try and throw down. And they love to wrap the cases around the axle with these procedural issues, standing or ripeness or mootness or whether it's an arm or all these other things that don't get to the ultimate issue of whether or not your constitutional rights are being violated. And that's unfortunately one of the reasons why a lot of these cases take longer than they really should, because you have to get through all these preliminary issues, these sort of sideshow issues first.
Well, and it looks like where they've got it now is failing on the plain text test. They also have it failing on the meaningful constraint test, but they say you can make an amended complaint and turn that in by June 25th. So what is the battle plan for this lawsuit moving forward? Is it to try to amend the complaint under theirs?
Well, I'm going to have to talk to the other lawyers on the team to make sure, but I believe what we're going to do is, because we have to pretty much, you can't really appeal from this. You generally don't, but I think we're going to amend the complaint, beef up the allegations that they're alleged that there is a meaningful constraint, and say why, 10% income or 11% excise tax put some people out of purchase. Some people don't have that money. Price of guns is high. You can't not people can't have you jack that up. You put all the fees on with the background check and the FSC and all the other fees that are tacked on top of the price of a gun, and you add 20-30% to the price of a firearm. That's a meaningful constraint. People don't have that kind of money to buy a gun with.
And then what? I mean, does it go back to another oral argument, or did the arguments happen on
Well, I'm
Tuesday?
sure they'll demur again. They'll demur again, and then there'll be another oral argument, and then we're still not even out of the pleading stage. What we need them to do is file an answer. Once they file an answer, that's the case is at issue. Then discovery can go on, and then you go towards a motion for a summary judgment or judgment on the pleadings or whatever. But you have to get through the pre-pleading stage by surviving these demur attacks first.
Well, another step up, I guess, in the rung of the ladder, but it just happens to be a very tall ladder. We're going to be here for every step of the way, though. Chuck, I appreciate you coming on and dispelling some of this stuff for us. Thank you for your time.
Always a pleasure, guys.
Absolutely. And guys, as always, please be sure to like, share, and subscribe to the videos. We're trying to bring this stuff to you as it comes out so that you can hear it from the attorneys that are filing this stuff. So please, if you can, like, share, and subscribe. Really helps get the information out as far and wide as possible. Thanks again, guys. We'll see you on the next one.